Happy Monday, and welcome to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about crimes committed on airplanes. Cases that should have gone to the Supreme Court of Canada, but didn't. Jean-Marie Alois Hoche was a French national who was on board a flight from Paris to Montreal. During the flight, it was alleged that Ms. Hoche had committed a number of offences. By virtue of the Criminal Code's provisions dealing with crimes committed on board aircrafts, the crimes were deemed to have been committed in Canada, and proceedings were commenced against her in Quebec. Under the Criminal Code, if a crime is committed on an airplane, the Attorney General must consent to the proceedings within 7 days of when they were brought. In this case, the Attorney General never gave any consent. The consent was given later, after the 7-day window had expired. Because the consent was given out of time, the Crown stayed the original charges against Ms. Hoche and then recommenced them on a new information. Ms. Hoche applied to the court, arguing that the information should be quashed and declared a nullity because the consent was not obtained in the required time frame. The Court of Appeal agreed, and the Supreme Court of Canada dismissed the application. And while this case seems relatively straightforward, the rule is that you're supposed to get consent, and if you don't get consent, you can't bring the proceedings, it does raise significant issues of national importance. Crimes aboard airplanes are very rarely prosecuted and very uncommon, and especially ones where the law of Canada would apply to the prosecution of those offences. And so clarity about what procedure can be followed and the importance of those steps in the procedure is something that is beneficial to all Canadians in understanding what is going to happen to them on board an aircraft if they commit a crime in Canadian jurisdiction on an aircraft. The other reason that this case was important and why the Supreme Court of Canada ought to have heard it is because it engages issues of national importance as they deal with the Crown staying charges and laying new informations to get around procedural defects in the circumstances that have happened. This is something that happens almost every day throughout this country, where there are problems in informations, Crown pulls the information, lays a new one, attempting to re-perfect the charge even without the defect that existed in the first place. This procedure has been criticized widely by defense counsel as being unfair and not putting the defense on notice about what the person is obligated to meet, particularly because often the prosecution can do this at a very late stage of the proceeding and still continue as though the original information was there all along. This is obviously problematic, and the Supreme Court of Canada could have chimed in just generally on the practice of Crown pulling in information, re-swearing a new information, when it is allowed, when it isn't allowed, when it's too prejudicial, and what the rules are surrounding this. Unfortunately, it's going to take another case for somebody with some questionable conduct on the part of the Crown before we know whether this practice should be encouraged or discouraged, or whether this case is really just something that is limited to airplanes. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.